Hey there, I'm estate planning attorney Paul Rabelais, and in this video, I'm going to talk about the estate planning problems for wealthy unmarried couples. What prompted this video is very recently I was talking to a couple. They were not married, but they'd been together for several years, and they had built a successful business. That now they had a large estate. They were trying to figure how they want to plan things for the future. So yeah, those unmarried couples do face a unique set of estate planning problems because the law offers far fewer default protections and fewer tax benefits compared to married couples. Let's look at what some of those are. First, we'll talk about there's no unlimited marital deduction for unmarried couples. If you're married, you can give to your spouse unlimited gifts without any gift tax consequences, and you can leave an unlimited amount of your estate to your surviving spouse. And whatever you leave to your surviving spouse gets deducted from your estate before these estate taxes are calculated. So for 2026, the exemption, the estate tax exemption is $15 million. The estate tax rate generally 40%. So let me give an example of this unmarried couple not being able to take advantage of the unlimited marital deduction. And so what I told them was, when one of them died, if they weren't married, and if one of them died, they would owe about $30 million to the IRS within 9 months of the first partner's death, based upon the size of their estate and based upon the fact that they cannot use this unlimited marital deduction. Were they married, they could set things up so that there wouldn't be any estate tax due upon the first spouse's death. And yes, that tax generally gets deferred until the surviving spouse dies, but maybe the surviving spouse would have years or decades to be able to plan to minimize that tax when the surviving spouse dies. So number one, no unlimited marital deduction for unmarried couples. Number two, no portability of the estate tax exemption. You see, married couples can combine their $15 million exemptions through portability, allowing the surviving spouse to use the deceased spouse's unused exclusion amount or exemption amount. So for example, if partner A dies with a $5 million estate, well, if they were married, if it was spouse A, then an estate tax could be filed after the first spouse dies, and that $10 million of unused exemption amount can be added to the surviving spouse's exemption amount to really increase how much the surviving spouse can leave to the heirs when the surviving spouse dies. But again, if you have an unmarried couple and partner A dies first with a $5 million estate, that $10 million unused exemption, it's just lost forever. The surviving spouse can't use it. Problem number three is the loss of step up in basis in community property states. You see, in community property states, all of the community property of a married couple gets a step up in basis when the first spouse dies. Yeah, you heard me right. It's not just the deceased spouse's half of the community property. People who live in community property states, I think, have a real big advantage because all of the community property gets a step up in basis when the first spouse dies. And so that can really minimize capital gains tax when that surviving spouse goes to sell assets. However, if a couple is unmarried, then the surviving partner's assets do not get a step up in basis when the first partner dies. So could be a big deal if a couple had grown a business together, started from scratch, and now it's very valuable. That step up of all of the community property when a married person dies can be a tremendous advantage. All right, number four, your default rules that exist if there's just no planning in place. And again, you can combat this with some planning, but if you have an unmarried couple and one partner gets sick, that other partner isn't authorized to make any medical decisions in the absence of some kind of healthcare proxy or healthcare or medical power of attorney. Also, if you have an unmarried couple and one partner dies, there's no automatic inheritance rights for this unmarried surviving partner. State law decides under the intestate laws who inherits when unmarried partner A dies, and all those intestate laws are based on blood relatives, or a legal marriage. So maybe one final tax matter is an unmarried surviving partner doesn't qualify for the spousal rollover as beneficiary of the IRA or 401k. So that surviving partner will have to take income taxable distributions sooner than a surviving spouse would. Now, I do realize there are a handful of states that recognize common law marriages, and some states that do recognize common law marriages, they have very strict requirements that are rarely met. So if you are in a situation where you have a significant other or a partner and you're not married and you've built an estate, you may want to take some of these considerations into effect. I never really like to see people get married or divorced solely for tax reasons, but again, good to make informed decisions. We'll see you next time.